Okay, so I got a few people typing that they can hear me. This may seem odd, but type if you're having trouble hearing me or if you're not seeing my screen. All right, so I guess it looks like we're good to go. So once again, welcome to our monthly webinar series, Extended Family Rights. Tonight we will be discussing several issues regarding grandparents' rights and for visitation, parenting time, and custody. Also step-parent rights, step-sibling rights, and we'll touch a little bit on third party, meaning anybody and everybody, their rights to both parenting time and custody of children who are not their own. Give you a little information about today's webinar. It's scheduled for 45 minutes. I do my best to keep it within that time frame. Sometimes it's a little longer, sometimes it's a little shorter. I never know how long it's going to take me to get through the information. And then afterwards, I do like to take as many questions as you will have, so that will sometimes cause it to go longer. I will stay here as long as it takes to get all questions answered. And I suggest, excuse me, that people write their questions in the pane where you just type your response throughout the webinar, even though I won't be addressing it as we go. I'll address them all at the end. But it's good if you write them when you're thinking about it so that you don't forget about it as we move on to other issues. Last thing about the webinar, it's, as you may notice, it's a one-way communication, so you can hear me, I can't hear you. I don't believe you see other people's names, but I'm not exactly sure, but I am fairly certain when you post questions, nobody else sees the question but me, and I don't identify whose question it is when I answer it. So you don't have to worry about putting up anything that anybody else is going to get to read. A little information about me. This is me for those who have not met me or aren't working with me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I've been a practicing attorney for about 20 years now. I started my career after law school doing a judicial clerkship in Bergen County, which means I worked as a judge for the judge's law clerk for the year. I then went to Kessler and Associates in Clifton, New Jersey. I did complex commercial litigation for a couple of years. Then I decided that I'd rather work with people instead of businesses, so I opened my own office in 1999 as a solo practitioner. And then from there, I almost immediately started to concentrate my practice into divorce, family law, and estate planning issues and litigation, which is what it is today. The Micklin Law Group was formed around 2010. We brought in a few associates. Those of you who are working with me would know them. I'm not going to take your time this evening to go through them, but if you'd like to know more about the attorneys in our firm, you can go to our website at micklinlawgroup.com, as well as to get additional information on me and my practice. Real quick, not that I'm trying to boast, these are some recent awards that either I or my firm have received. They're a little outdated. I received most of these also for 2015, and several more that aren't listed here. And I put these up here not because I want people to think that I'm so great, but it's important to know who you're dealing with. I often say to clients, you don't know if you had a good attorney until afterwards. So it's important to do research, make sure that the people that you're dealing with know exactly what they're talking about, especially on your specific issues. All right, so let's move right into it. Let's start with the biggest topic about these issues, the most common, and it's grandparents' rights. Very, very popular topic, has been for decades now as the law is developing. So let's first talk about the first case that actually opened the door, let's say, to grandparents' rights, and that's the Supreme Court case of Troxel versus Granville. The citation is 530 U.S. United States Reporter, page 57. It was decided in the year 2000. This basically said, and this case is the hallmark for all the cases that have followed, that in order for a grandparent to seek custody, or what was called at that time visitation, we now call it parenting time, they need to show at a minimum that's in the child's best interest. Now, this is a standard that you'll see in almost all issues relating to children, whether it's visitation, parenting time, child support, abuse and neglect, which we'll also touch on. It's a very, very common standard. And that's helpful to know in the sense that you know where you're starting from. It's hard or it's not helpful in the sense that there's really nothing that clearly defines what that is. Now you'll see through some of the statutes and cases that we will go through in a moment that The courts do attempt to define certain things to look at, but this is what you'll see over and over again, the standard you'll see over and over again when it comes to children's issues. So it's important to keep it in your mind. It's also important to use the phrase when you are in court or when you are filing papers seeking these types of issues, whether or not you're going to go through the specific criteria, but you want to at least use this phrase because it will catch everybody's attention. So let's look at what New Jersey has done. Here is a citation for the statute that allows for grandparents' rights in New Jersey. It's New Jersey statutes annotated, Title 9, paragraph 2-7.1. You want to write that down if you are involved in these issues, because you can run that through a web browser and you'll be able to pull up most of the information. I will also have this recording available for you after today if you're interested in it. So let's look at some of the factors that are set forth in the NJSA statute. It says that, it begins with a parent denying a grandparent the right for, and again, they call it visits, even though it's commonly going to be used as parenting time, but for different reasons. You have the right to make an application. Now, what's important about the first part of this statute is that any grandparent has the right. You'll see later that it's not just limited to grandparents, but the statute is. Now, the second part, and the most important, is the burden of proof. And you'll see how in a moment how this is developed. But essentially, the burden of proof, and that's what you have to show the judge in order to win the right to seek visitation or custody of your children's children, is what's called a preponderance of the evidence. Now, this is another phrase that you will hear very often through the legal system, and it doesn't necessarily have a specific quantitative definition, meaning there's nowhere you can go and find out exactly what amount of proof is a preponderance. Many judges will describe it, in some cases will describe it as more than 50%. But again, not much help. It's sort of what judges will use to get the decision that they want to get. If they want to say it's not entitled to, you're not entitled to, they'll say you didn't meet the preponderance. If they said that you are, then they'll say you met the burden of preponderance of the evidence. Very difficult to define. My advice is to have as much as possible from the beginning so that you have the best potential showing for the burden of proof, whether it's you or the other side that needs to address that. The reason I say that is because the burden of proof is also rebuttable, which means that if the grandparent can show that he or she was a full-time caretaker of the child, then it's actually the burden of proof on the parents to show that the visitation should not be allowed. So it sort of shifts the burden of proof to the parent. Now, what it does not say is how long you need to have been the full-time caretaker and what the full-time caretaker would be considered when you look at the fact that now a lot of families are divided and each parent sometimes only has the children for half of the time or 1 week at a time, and then 1 week they don't have it. So defining what a full-time caregiver is going to also, I think, change with the way the blended families have changed. There are some more statutory factors. They look at the relationship between the child and the grandparent. So, and this is probably the most important thing. So you want to have as many documents and witnesses as you can when you're first walking into court with an application on these kinds of issues. They'll look at the relationship between the child's parents and the grandparent, or at least the child or the person with whom the child is residing. Because again, you may have the other grandparent, for instance, being the caregiver of the children, and the other grandparent is petitioning, or you may have divorced grandparents, and the divorced grandparent is seeking from the other grandparent who has custody of their children's children. So as you can see, I mean, I don't want to belabor the point, but in the new levels of blended families we have, these are areas that are going to quickly develop. Now, moving on to the last factor is the time that has elapsed from the last contact with the child. Now, this is an important issue because most lawyers, good lawyers, will tell you don't run into court necessarily with an application for many reasons. You want to maybe first try to resolve it with the parents directly. It's faster, it's cheaper, and you have less hurt feelings, but you have to balance it against this factor that says that if you wait too long, it may actually hurt your application. It may be one of the factors that the court counts against you. Now, these aren't the only factors. There's also the effect that the visitation will have on the relationship of the child and the child's parent, or again, the child with the person whom the child lives with. Now, for instance, if you're the parent and you don't have a good relationship with your parent, or the grandparent is your ex-spouse's parent, so let's say it's your ex-husband's parent seeking visitation with your children, that could interfere with the parent's relationship to the child, not intentionally or outwardly, but it can have an effect, and it's important that the court wants to make sure not to do anything. And then now also, if the parents are divorced, we'll look at the time sharing agreement, because like I said a moment ago, you now have two parents who are already sharing time with the child. They're already losing some time. So to further invade their own time with their own child, the courts are going to want to consider whether or not that's actually fair and if it's in the child's best interest. Additionally, they will look at the good faith of the grandparent filing the application. This is going to be important, I think, also in divorce cases where either grandparents are divorced or parents are divorced. Sometimes you'll have a grandparent that's filing just because their child actually wants to get more parenting time and couldn't get it through their own divorce. So they're stepping in, or they're angry at their ex-daughter-in-law for divorcing their son, so they're filing for parenting time. So the courts are going to look at that and determine whether or not. So it's important to try to maintain as good a relationship with the natural parents as you can before seeking this kind of intervention. And then the last two factors, any history of abuse or neglect by the grandparents. So if there's been a history either with the child or the parents, meaning grandparents' children, the natural parents, or their children. If there's any abuse from the grandparents on either parts of this family, it will significantly affect it. And then lastly, what the courts always have, or not the courts, the legislature always has in statute, is any other factor relevant to the best interest of the child. And this is helpful and hurtful because, again, it's not often well defined, but at least it's something to use if you don't have a lot to support the other factors. You have this sort of catch-all that you can rely on. But now they'll mostly focus on the harm to the children. What they're trying to do, what the statutes and the judges need to do, is balance the constitutional right of a parent to raise their own child and have it free from interference, both by another party, but more importantly by the state. Most people don't want the government getting involved in their intimate relationships, whether it's their parenting or their marriage or their partners. So we need to know that we are free from that kind of intrusion. But on the flip side, states need to protect children. So they will cautiously involve themselves in these matters when it's appropriate based on the factors that we had just mentioned in some of the cases and issues that we'll talk about in a minute. Now, a prima facie case is, or at least it was, that you needed to show serious physical or psychological harm to the child. And again, this is going back to what I just said a moment ago, that because it's such a significant constitutional right that they're invading, they want to make sure that there's a significant reason. It has to be more than just, I miss my grandchild, or I don't think they're good parents and they need my involvement. So it really needs to be something more than that. Now, serious physical or psychological harm, we'll talk about a little bit of how you show that and what that may mean in a couple of seconds. Let's first take a look at some of what New Jersey has said specifically on this issue. So the first case we have in New Jersey is Moriarty versus Brandt in 2003. It's a New Jersey Supreme Court case. The reporter is volume 177, page 84. Again, you can really paste this kind of a site into a web browser now and get most of this information, so you don't really need to know the sites. The court in this case held that you needed to show that denial of the parent visitation, I may accidentally call it parenting time because it's commonly what we use, the denial of visitation would be detrimental to the child. And what they're saying is a little bit of what the United States Supreme Court is saying, is that they need to protect the due process rights of competent parents. You need to know as a parent that you're allowed to raise your child as you see fit. So there's a presumption in favor of the parent's decision. If the parent says, I don't want my parents to see my children, I don't want my husband's parents to see my children, the court should respect that, and they will, absent the showing of harm or issues that we talk about. Now, no right, including this one, is absolute, so they can invade it, but again, it's got to be on a proper showing. Next case was in 2005. Now, this was an appellate division case, which is higher than a trial court level, but not as high as the Supreme Court in either the state or in federal government. Moriarty versus Cannon, 375 volume, New Jersey Superior Court Reporter, page 221. This was a request for a visitation with a 3-year-old. Now, the court sort of made a general kind of finding, and they said that there just wasn't enough harm alleged by the grandparents. The loss of potential happy memories and the general heard that will always accompany, admittedly, a change in relationship or a loss of family members. Not enough for the court to invade this kind of a relationship. So the court here is not saying that the loss of contact with a grandparent, whether it's one that's intimately involved in a family or one that's even cursorily involved in a family, they're not saying that that's not harmful. They're actually acknowledging that it is harmful in some manner. Loss of a family member in any way is always harmful, but it's not harmful enough. And that's the important thing to remember, that there's got to be enough of a risk to the child before they're going to invade this type of a relationship. So now moving on to 2005, we have Daniels versus Daniels at 381, New Jersey Super 286. This was an application to see two children. They were 3 and 6. The grandparent, the grandmother, had significant visitation with the child and did have, by the court's own finding, a strong and loving relationship. And again, the court acknowledged that that is a very important relationship. They acknowledged that it's very harmful for a child to lose it. But again, it wasn't enough. They said that it needed to be more substantial than this type of harm. It needed to be more than the normal loss and hardship you will experience by breaking up a family. Turning to 2007, Renty versus Renty, 390, New Jersey Super 47. Now here they had even more significant contact with the grandparents. There was 2 years of the first 2 years of the child's life that the grandparents were constantly involved, babysitting a great deal, and they still denied it. And that's important because those of you that have children will know that the first 2 years of a child's life can be some of the most significant bonding and development years of a child. So a lot more can happen in that shorter period than if the child's 13. So it was significant that despite this significant involvement over this significant period of time, the court still said it was too little. It wasn't enough. So let's take a look at where the courts do allow it. Here we have a 2012 case, torturous versus Manotaur. I'm going to skip the site. And what that says at the end there, just if you're curious, assert denied means that it was taken to the New Jersey Supreme Court, which is right up here. And it was denied. They denied to even hear the issue. Just important to know that they're basically saying that this issue didn't need to be reconsidered. And they're basically saying that this was an issue that helped define when a grandparent would be able to actually step in. And they said when a grandparent stands in parity to an actual parent, you become what's called a psychological parent of the child. And this was the first case that really said this is how we're going to look at it. So if you, as a grandparent, act as the parent, then we're going to consider that relationship should continue. Now, what that means is going to depend on the actual facts of the circumstances, the involvement in parenting time responsibilities, the amount of time together, the amount of time apart, and the overall involvement of the grandparent in the child's life, like school events and teacher conferences, doctor visits, and things like that, like if you were an actual parent. So now we have a little more. The court in this case also had found that the family had consented to, and they've used these to define what a psychological parent would be, that the natural family consented to and fostered this relationship of the, let's say, grandparent to form the parental relationship. Because you couldn't really have, in very limited circumstances, you could have a child and a grandparent bond in a parent-like manner without the natural parents knowing and consenting. Whether they liked it or not isn't the issue. It's whether or not they acquiesced at least. And they must have lived together in the same household. And I think that's because without that, it's hard to suggest that you could be a parent-like influence without having lived in the same house. Let's turn to a little bit more. What this case also said, you had to assume the responsibilities of acting like a parent, child's care, education, development, Child support is very important. Now, they emphasize this because I think personally the state has a lot of interest in child support because they don't want to support the children. So your ability and your desire in the past to have supported the child financially will greatly affect, I think, a decision about whether or not you stand in a similar shoe as a parent, as a psychological parent. And it had to have been for a significant length of time to have created a bond between you and the child. And again, that goes to the living together. There's no way you could argue that you are like a parent if you don't have a long-term bond. Now let's look at another case. Came down in 2013, Copel versus Pearson. Now in this case, as you'll see here, the grandmother actually lived with the child from when the child was a few months old through 6 years old, and had assumed a substantial responsibility towards this child as almost the court found the principal caregiver. So here's a case where they found someone who had stood in the shoes as a parent, a psychological parent. So you can see, living there, taking on substantial responsibilities for a long period of time is what was required and probably still is going to be required. Now what's happened recently with RK and AK in 2014 was the court addressed finally what was a very big, complicated issue in grandparent rights. And that was you could have a client or a grandparent who would come and say, I've had all these great relationships, I've been there for all these years, I've satisfied the psychological parent, but you'd have no way to show any actual harm. Now the court's saying you need substantial material detriment to the child. So you can only do that with an expert witness. You can only get an expert witness if you could get access to the child, which you wouldn't because the person that's fighting you doesn't want to give you visitation in the first place. So you'd march into court with a great application, but no expert report, and the court would say, well, you can't prove that there's any harm. And they finally recognized that that's unfair because if there is a risk of harm to the court or to the child, then they need to give a chance to have it be heard. So simply put, what this case decided is that the grandparents must be afforded an opportunity to be heard by giving a chance to get some of this evidence that's necessary. So they did two things. They opened up the right to have discovery, which is the right to get and exchange information. They also expanded the type of proof that they would listen to. And instead of making it required to be expert reports, they now will take it from witnesses or opinion testimony, which greatly reduced the difficulty in providing proof of harm. Now you could have your neighbors, your friends, your family, even your family doctor give a report where before you needed a psychologist or psychiatrist or a forensic to actually do it, and you couldn't get it. So this was a very big step in sort of broadening grandparents' rights to get visitation or custody of children. So let's move on. I'm running probably a little bit behind, so I'm going to do my best to kind of move quicker through some of this because that's most of the grandparent issues, and I think probably most of the significant issues that a lot of people want to know about. So let's move into step parents, give you a site to look for some of this. Basically, this site is saying in 1987, there was 1 out of 5 American children living in step families. And the purpose of the next couple of slides is just to show you how that has been growing and how the issues of step parent issues will develop with it. Now, right now, there's not a great deal of law in it, and we'll see that it's the type of families, blended families that are created is expanding so much. I think the law needs to quickly come up to speed. I was looking at more recently now, they're saying that 1 in 3 Americans is involved in a step family, and there's 1,300 new step families formed each and every day. And more importantly, the next paragraph talks about that 50% of children under 13 as of 2004, and this is now even still almost a decade ago, more than a decade ago, over 50% were living with one biological parent and a step parent. Now, before 1982, step parents didn't have any standing to make a claim. So this is just a quick moment to show you that these stats are still even not updated that much, and it's changing so quick that it's hard to say where these rights are going to go. But I think they're going to follow the same kind of course as the grandparent rights, and that they'll start to quickly broaden it because of the nature of the change in blended families. So now, New Jersey does have some precedents for step parents being allowed contact, and we'll talk about it a little bit later the specifics. But again, it's the higher standard of the best interest, which was similar to the grandparent issues. You'll see when a step parent is looking to maintain contact with a adopted child or a stepchild afterwards. Now, again, here are some of the things. The next paragraph we'll talk about a little bit, some of the issues that the courts will look at. Actually, I want to make sure that we're on the same page here. Yes, okay, here we go. This is the bottom paragraph talks about things that the court will not look to, like support of the child, again, comes up as being very important. The income of the step parent is generally not considered when it comes to parenting time, because they're not going to say whether or not you make enough to visit with your child or your stepchild, but they will make sure that there is an expectation of providing support, because once again, we see that New Jersey's case law greatly supports child support, because again, the state doesn't want to, as a very sincere public policy of not having to support children, or I should say different. Their public policies to have the parents support children. So let's look at some of the recent developments about step parents. We do have a 2014 case. This was a lesbian family couple and broke up, and the ex-partner sued for parenting time the child that they lived with since he was 18 months old. Now, they were together for 7 years, and when they left, or when the one partner left, the biological mother tried to prevent parenting time, so the ex-partner went. And originally, the case had denied this ex-partner, parenting time or visitation with the child by finding that if there are two fit parents, then basically the child doesn't need any more. And that was, I have my reasons for thinking why they did that at this point in time, but it was reversed, as you see in the last paragraph, because the purpose of these statutes is to protect the child, not to say there's enough parenting, but to show that there's no harm to a child, that's in the child's best interest. So I think we even see an expansion of step-parent rights in the last couple of years. And the court found the same thing, similar again to the grandparents' rights, that if a person lives and cares for a child for a significant time and develops a bond with the either consent or acquiescence of the natural parent, then they're going to say, at least we should look at this issue. They're going to say that there could be significant harm that needs to be addressed before. Now, I'm going to step past this because I think most of this issue, and like I said, I'm recording it in case anybody needs it, is very similar to the issues and the findings in the grandparents case. And as the case law develops, I think it's also going to follow almost in tandem that. So what I think we're going to see is an expansion of what type of proof can be used by step parents. Like I said, when we brought in the rights of grandparents to use expert testimony and fact testimony and opinions, I think we're going to see this developing also for step parents. I think it's going to run a parallel type of course. So what I want to turn to for a couple minutes also now is step siblings, which is a very new issue. I think it was almost common sense to see that this would have developed, but it didn't for some time. As of today, the Supreme Court has not even had to yet address it. And so there's no constitutional right for siblings to visit with one another, step siblings to visit with one another, actually, or siblings for that matter. I don't think either issue has been addressed. Now, the Supreme Court sidesteps it by saying it's a freedom of association for both the parents as well as the children to, again, determine what type of relationship they have and be free from governmental interference with it. In my opinion, the Supreme Court with this and most issues will sidestep it until it's forced to make a decision, and then we'll see it developing. But that doesn't mean that it hasn't been. And a quick constitutional law point before we move into what New Jersey said is that the reason I said this, the reason it's important to know the Supreme Court has not ruled is the states are considered sovereigns unto themselves. So the states are, by our federal constitution, allowed to make laws to govern themselves. The only time that they can't is if it conflicts with federal law or the Constitution. So the fact that the U.S. Supreme Court has not addressed it allows states to make its specific own either case decisions or statutes, so long as there's no conflict with federal law. So let's see what New Jersey has done. Now, we have a statute at NJSA 9:2-7.1 again, which I believe is what we also referenced in the first place, that provides sibling visitation, again by preponderance of the evidence and best interest of the child. So it's almost a cut and paste standard that you will see in this and many other issues. Now, I think it's going to be a little less than the standard proof needed for grandparents, because I think stepchildren, step-siblings usually spend more time together, and more often spend more time together, and more often have a much closer bond. Now, what we don't have in the grandparent issues is the parental responsibility or acting like a parent. That's going to be absent because they're siblings, they're peers. But it's going to focus again on, one, the best interest, and two, the psychological harm that can be caused by the removal. So some of these issues are going to, I think, develop parallel to grandparents' rights, but many of them are going to be absent. So let's look at some of the factors that the court's going to consider for sibling visitation. And you're going to see, again, it's almost a cut and paste from the grandparents. They're going to look at the relationship between the child and its sibling, the relationship between the child's parents and the person or sibling that they're residing with, so the natural parents and the siblings, and the time that's elapsed, the absence between the contact between the parents. Now, this may be a little more difficult because if it's truly the sibling who's motivating this petition or this issue, they're often young and without the means or ability to access courts without their parent. So they need to sort of have their parent on board, and getting that kind of support may actually cause a delay. So I think it's important to remember that issue if you're going to be bringing a sibling petition on behalf of either yourself or one of your children, to realize that there is naturally going to be a time elapsed between the residing together or the bonding time and the petition. Now, there's a couple more. They're going to look at, again, the effect of visitation between the child and the child's parents or whom the child's living with if it's not a natural parent. And if it's a divorced family, they're going to look at the time sharing because, once again, this similarly will invade on the natural parent's already limited amount of parenting time. That's not it. I was just getting a sip of coffee. They'll look also at the good faith of the sibling or grandparent in filing the application. They'll look at the history of abuse, and then, once again, the ever famous that you'll see almost everywhere, any other relevant factor. Now, I put a note here that says that the legislature has not actually defined what a sibling relationship is. And the reason that is, it's another quick, constitutional lesson, is we have in our country and in all of our states a separation of powers which gives certain branches of government certain rights. So the judges interpret the law, the legislature writes the law. So if the legislature does write a definition or codifies these factors, it will take the discretion away from the judges to find these issues on their own. So like this any other factor relevant could be defined or could even be eliminated by the legislature, thereby sort of handcuffing judges in their decisions. Like we recently saw actually in the alimony reform statute. I'm going to go into depth about that. That's a different webinar topic you can download. But that was done because they wanted to take discretion out of the hands of judges. They wanted to have more certainty for litigants going in. So we'll take a quick look at how the statute developed historically. We have a decision in 1985. Now, this decision, I won't run through the citation for you, but this is important because here you'll see it's a chancery division. That's what the chancery division, which is where the family court is. This means there's three main levels to the reports you'll see in states. There's a chancery division, there's a trial court division, which will be here, NJ Super, and then there's the Supreme Court, which would be just the NJ. This distinction is important because what this really means is this was a decision written by a trial court judge, and it was published by the appellate division because it was a very good decision, but it's not technically binding on any other judge. It's at best persuasive. But the factors policy means it's very persuasive because there probably, at this time, there hadn't been anything else written on the subject. Now, this case established what I wrote as a fundamental right of sibling visitation, which means it's another way of saying it's a constitutional right, that it rises to the level of constitutional protection. And secondly, that the courts have what's called equitable jurisdiction to grant sibling visitation. Now, equitable jurisdiction means just the power of this court to act. Equitable jurisdiction means to be able to do something other than award money for the damages. So by saying equitable jurisdiction, that means they have the power to actually grant the visitation as opposed to just compensating you for a loss. Next, we have Pullman versus Pullman, 1988. You'll also see it's a Chancery Division case. It was distinguishing this case from the LG case that we saw just a moment ago. This court held that a husband-son by a prior marriage could not have parenting or visitation with three of his half-siblings. Again, it came down to that while there is a statute and there is a right, it doesn't necessarily get triggered in all cases. There needs to be something more than just saying there's going to be a loss to the relationship. Here, there was only a brief separation, so they couldn't say there was going to be any harm. They didn't know where it would go going forward, and it was denied. Now we're going to move a little bit into third-party custody rights, which means basically anybody else. Now, what we have here is Title IX abuse and neglect, which is typically your Division of Child Protection and Permanency, which is DCP&P, formerly known as DIFAS. They are generally the people who will petition for custody in an abuse and neglect situation, which is more often than not the only way any third person can petition for custody of another person's child. Now, I'm going to go quickly through what they do first, but what I want to first say about that is just because this title is generally initiated by DCP&P and or DIFAS, as you may know them, it doesn't mean that it's only initiated by them. Any person is allowed to seek custody of any other child if there's a good reason, if there's a best interest or a potential psychological harm to the child. Anybody can step up. It's commonly DCP&P, so most people don't realize that they have that right and that they also need to protect themselves against other people who have this right to seek custody of their own children. So DCP&P will investigate abuses of allegations of abuse or neglect. They are required to make a finding of unfounded or substantiated. Now, this distinction, when they're called to investigate these reports, doesn't mean it didn't happen. It just means that they couldn't prove it or they didn't prove it. Now, there's actually a third distinction that they've involved recently. I'm not going to go into it because it's beyond what we need to know. But basically, they're out to investigate whether or not they can document and prove if it's been substantiated or if it occurred. If they do deem it to be substantiated, then they file a complaint in family court. The Attorney General's office will represent DCP&P. That's the technical attorney for DCP&P or DIFAS. The children will have a lawyer appointed for them. They will have a law guardian appointed. And then the parents can either represent themselves, they can have private attorneys, and if they are indigent, which in many of the cases in a Title IX case they will have a court-appointed public defender. Let's talk a little bit quickly about the types of proceedings in abuse and neglect. They will first start, like any other lawsuit, by filing a complaint for having the child placed in supervision. It will most often be an emergent application, and most of the time the parent doesn't actually receive a copy of it. Sometimes they do in advance, but other times they just get a letter or a phone call that says, hey, we're going into court on this day. Once the hearings have begun and the parents are on notice and appear and a few other things happen, they will then schedule a fact-finding hearing. Fact-finding hearing is an early hearing that determines, the court needs to determine if there was enough proof in the abuse and neglect complaint to continue the lawsuit. Again, not that it happened and not that they can prove all of it, but that there's enough, like a scintilla of evidence to suggest it was abuse and neglect, which most cases, if it reached this level, there would be. Next, they have dispositional hearings, usually every couple months. They will determine whether or not the family that has been alleged to abuse or neglect their children need any kind of special services. Children may or may not be in placement. They may remain in the home. They may be removed. And then finally, they'll have a permanency hearing, usually about a year and a half into the litigation. They're required to have some kind of permanency plan. And that will say either the children are being returned or the case is being dismissed, or they'll continue supervision. But they must have, at some point, a final decision so that the parents know that it's coming to an end. Now, it says here, and this is in this case at almost any stage, they can grant emergent relief if the child is found to be in imminent and potentially irreparable harm. They can remove the child. They can remove the child even without notice to the parents if there's that great of a risk. And this also goes for third parties. If you know of a child that you're intimately connected to that you believe is being abused, you can also petition similarly for removal of the child to be placed with you. It's a very challenging thing, and not many people are successful in it, but the rights do exist. So I want to talk a little bit about a Latin term called in loco parentis. Now, this is a term kind of global to all of these issues. In the earlier part of this webinar, we talked about a psychological parent. So in loco parentis is just a Latin term that means in the place of a parent. Now, this is going to be another phrase, a buzzword you're going to hear a lot, but you also want to keep it in mind. This has been defined when, again, a step parent actively and voluntarily interferes with a child's ability to receive support. So let's say you are I'm going to go an example because the way it's defined makes it sound bad, but voluntarily interfering with support could be more commonly when one person marries another person with children, and that person takes on the support of the children and possibly even prevents the other parent, the ex-spouse, from supporting, or encourages, let's say the mother now, let's say encourages the other parent not to file for support. These things have actively interfered with the natural parent's ability to pay support for this child. So the court's going to say that you stood in the shoes of a parent. You took on the support. And again, it goes back to the state's desire to make sure that children are supported. Now, again, factors that the court will look at. One is that the natural biological parent, usually one of them is not in the picture. It could be both, I guess, in many circumstances. They've known this child since the child was very young. The child is what they say emotionally and financially reliant on the step parent. And again, you see emotionally is important, but they throw in the financially, it's going to be a very significant issue. The courts in New Jersey want to focus on, again, the best interest of the child. Now, they don't want a child, whether it's a stepchild or a natural child, to lose both emotional and financial support. And not just because, again, like I keep harping that they don't want to have to be the ones to support it, but this child has developed a life and has been accustomed to a certain life based on the support. To take it away is going to be very traumatic. The courts acknowledge that there's no legal obligation for a step parent to emotionally support a child. And you can't order a person to emotionally support, but you can order them to financially support them. It's sort of like, unfortunately, you can't make somebody a good parent, but you can certainly make them pay child support, they say. Now, a lot of this, and this the last paragraph goes into, a lot of it is, again, based on the conduct of the parent. Usually there's going to be, in all these cases, grandparents, step-parents, I don't know about step-siblings, but definitely step-parents and any third party, that this party is not only taken on parental responsibilities, but has also in some way prevented the natural parents from being able to, or the natural parents just weren't around and available to, so they took on that role. That, I believe, is the last one. Here's some information if you want to jot down quickly, if you don't have it, how to contact me with any information that you may not get today. Actually, I was going to do a poll, but I won't. Hopefully you got that down. So I'm going to open up to see if there's any questions. Again, I'm going to stay as long as it takes to answer them. All right, hopefully. Okay, the first question I see is, how do you prove psychological harm, especially with a 5.5-year-old? Well, and that's always a difficult issue. Fortunately, right now, you hope to be able to prove it with opinion testimony, witness testimony, possibly your own testimony. But ultimately, if you get over that threshold, what you need to do is hire a psychological expert, a forensic psychologist, to actually interview the child, interview the parents, interview the petitioning step parent or grandparent, and evaluate if there's a bond and what they believe, he or she believes, would be the harm to the child if the bond was broken. Now, the natural parents will likely get their own report and say just the opposite. Now it becomes an issue for courts to decide. It's sort of like a battle of the experts. The next question, hopefully a couple of people mentioned that slides weren't moving. I hope that's just because I moved the slides, and I'm hoping it passed since we began. Okay, I have a request to email the slides. I certainly will. Can somebody just type up here and tell me if you weren't able to see the slides moving through the presentation? Because I didn't know that. I didn't get to see these questions before, so I apologize if you were stuck on the same slide. It should have been showing all of them moving. Somebody just type up into the. Okay, I got one post that you couldn't see. You couldn't see any of the slides whatsoever? Still waiting for a response. You only saw the first one. Wow, okay. Well, I'm really sorry. I don't know why that is. If it's showing the screen and the slides, why it wouldn't move. So I turned it off now. I'm sorry. I'll have to look at that. I can certainly. I can email you a link to the recording, so you'll have the slides and the recording. I'll send you both. I'll send you the PowerPoint and the recording, so that you can either just read the slides if you want, or you can listen to the whole presentation and just go through it again if you want. My apologies. I have no idea why that would have done that, so I'll have to look into it. I've never had that problem before. My apologies. Any other questions while we're sitting here? Okay, then with that, I'm going to wish you a good evening. I will get this information out to you. It may take me a day or two to get it out to everybody, but I will. I will also send you invitations to our next webinar. I'm not exactly sure what our topic is going to be. If you want to email me some things you might want to see in future webinars, certainly take that into account. And with that, I wish everybody a good night.